guys, happy again to be talking with you. Welcome to another series, another module in the series. This time around, this module will focus on Brown laws. Brown laws is the third among the modules that focus on laws that protect the environment. Okay, it is also the third in the series of 4 modules, so it's the penultimate module. It's the second to the last module. Okay, now as I said, Brown laws focus also on protection of the environment, but it differs significantly to that of the other laws that we covered, the other modules. Let me explain. Green laws, for example, the protection that it focused on was on flora, fauna, as well as wildlife and land ecosystems. Blue laws also had a similar protection or protection focus. The aim of blue laws is to protect coastal and marine wildlife as well as their ecosystems and resources. Brown laws, on the other hand, focuses entirely on pollution control. Okay, pollution control. Okay, as well the regulation of specific activities that could affect the environment. Okay, the laws and rules under Brown laws include those that aim at about 4 specific areas. The first one is in controlling toxic substances and hazardous wastes. The second is on effective management of solid waste. The third is on policing air and water quality. And the fourth is providing means to assess environmental impact. So these 4 areas are actually what comprises the entire collection of laws under Brown laws. However, in this special certificate program, there are only 2 that are covered. So those are the 2 that we will focus our attention to today. Okay, and these 2 are the one that focuses on policing air and water quality, and then the second is on managing solid waste. I have broken these 2 into their own lessons, so you have lesson 1 and 2. Lesson 1 on policing air and water quality is going to focus, or at least it'll give attention to, or it'll reference 2 laws. The first one is the Clean Air Act, and then the second is the Clean Water Act. For lesson 2 on managing solid waste, there will be 1 law which focuses specifically on that subject matter. Okay, so having said that, having given you an introduction of what's going to be happening, what our focus will be, I think at this point we're about ready to get started. So why don't we go ahead and begin to look at lesson number 1. The first law is the Philippine Clean Air Act of 1999, otherwise referred to as Republic Act number 8749, and the second one is the Philippine Clean Water Act of 2004, Republic Act number 9275. Okay, now these 2 laws, for these 2 laws, we're going to be answering the same 3 questions that we were asking the other laws that we've since covered thus far. Okay, so we'll start with the Clean Air Act, and we'll ask the first question: what is this law about? And we have our answer. Fundamentally, this law, Clean Air Act of 1999, is about controlling air pollution. Controlling air pollution. The title, in fact, or the law, in giving it a descriptive title, even says that it is an act that provides for a comprehensive policy on controlling air pollution. In other words, comprehensive air pollution control policy. Okay. Now, because this is a little different, these Brown laws are a little different. in their focus. They're focusing not necessarily on a specific resource, but the need to control the pollution in those resources. Unlike the other laws, you might recall, like in green laws, it was about protecting flora and fauna, including wildlife. And then the blue laws, the same thing. We're controlling some resource or protecting some resource. Here it's a little different, and because of that, I think medyo broad ito eh. When we say controlling air pollution, medyo may pagka-broad siya. It gives us a general idea of what the law is all about, but I think there might be need to dig just a little bit deeper to help us better understand what this law is all about. So why don't we do that? So we're going to look at what the law says about what this comprehensive air pollution control policy provides. Okay. First thing it says is that it shall pursue a policy of balancing development and environmental protection, and that it shall also pursue a framework based on sustainable development. Okay. I presented these two bullet points together because they really speak to the same thing, which is sustainable development. The first one, balancing development and environmental protection, is really a means to attain sustainable development. Okay, and it may seem a little different. It's phrased a little different, but when we say balancing development and environmental protection, this is no different from what we've said earlier about the need to balance, the need to protect these valuable resources, and the ability to use them. Siyempre, if we use them, we want to control that so that we are not depleting these limited resources. Okay, so here it's just phrased it's the same thing, but it's phrased a little differently. It's talking about development, okay, as the utilization. But it's saying the same thing. And of course, this idea of balancing development and environment protection really talks about, as I said earlier, attaining sustainable development. So let's talk a little bit about what sustainable development is. The United Nations, in actually one of the commissions there, who in fact even coined the phrase sustainable development, actually defined it. It said that development, or rather sustainable development, is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. So medyo hindi nagkakalayo sa balancing, that statement about balancing utilization or development with protection of the limited resources, the environmental resources. So it's no different from that, right? The only thing that it really seems to say a little differently is yung purpose for the need to balance. Okay, and the purpose, of course, is so that the future generations, we're not compromising the ability of future generations to meet their own needs. Okay, so yan ang difference, but they're really talking about the same. So since in defining sustainable development, it says that it is development that meets the needs, blah, 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 blah. So let's talk about what it means by development. Well, in simple terms, if we just look up the dictionary, the development is really a process, diba? It's a process in which someone or something grows or changes and becomes more advanced, okay? So that's what we're talking about here. When we say development, it's the same thing as utilization, but I think what makes it a little different is it speaks to the process that you're using, okay, that aims to enable growth or allows one or that something to become more advanced. I guess parang yung internet. The internet developed in the United States, commercialized some 20 plus years ago. Not everybody was connected to it, but in time, a lot of industries joined the bandwagon. So naturally, other countries needed to do the same. Not just countries, but other industries needed to do the same. And in order for them to participate, they would, have to naturally develop their infrastructure. Okay, and of course that involves, using perhaps limited resources, like additional electricity, additional equipment that uses whatever resource. So it's having to tap some resources in order for them to develop. Okay. Likewise, it speaks of the benefit that if they're able to do that, that they're able to grow and become more advanced, and naturally they'll be able to play into the to that new medium. Okay, so that's kind of what we're talking about here. It's utilization, but the law used the word development because it's talking about something that is not just for the sake of using it, but to actually, enable growth, advance, and so forth. So now, since the resource that we're talking about here is not something that requires a conscious decision to use, okay, then it's kind of special, right? In a couple of ways. Number one, as I said, it does not require a conscious decision. So people just use it, okay? People just use it, Every one of us, we breathe the air without having to decide if we're going to breathe it or not. We've started to use this resource ever since we were born. And the only time that we'll stop using it, of course, is when we die, right? So we're using the resource. And our use of it, you can say, involves, is really development, and that's probably why they're using the word development here. Say we breathe it every day, we exercise, we breathe it even more so, we work hard, and we breathe it more so, and then, when we go out to party, we kind of abuse it also. Not just when we breathe out carbon dioxide, but when we smoke cigarettes, when we use our cars, and our cars, since they use fossil fuel, they'll belch out carbon monoxide. So there's that, right? But all of those things are intended for our growth, for our personal growth, for our personal development. So I guess that's a good way to kind of exemplify why instead of utilization they're using development. Okay, so anyway, that's that. I hope this kind of makes sense. But let's move forward and see what else it says. Okay, it says also that the program, or at least the policy, should formulate. The policy says that there's need to formulate a national program. Okay, so the word national used here already speaks to the scope. Hindi lang sa Metro Manila, hindi lang a particular city, but the entire nation. Okay, so it speaks to that as its scope. The word holistic, in simple terms, is derived from the word holistic is derived from the word whole, W-H-O-L-E. Okay, so that's why you'll see on the bottom left corner I use this circle as an example, and this circle is the way the United Nations is trying to demonstrate all of the aspects of their sustainable development goals. So you'll see it's like a salvavidas, it's like a wheel, all right? And on the outer layer, there's different things listed, and those things represent particular aspects of their sustainable development goal. And then there are others also in this inner green part of the wheel. So the whole thing represents, of course, their sustainable development goal. So same with what we're talking about here when we say holistic. It should be all-encompassing. It should be all-encompassing It's an all-encompassing national program aimed at managing and controlling air pollution. Okay, so that's really all it says. Now, in addition to this, it says that this holistic national program should focus on pollution prevention. Okay, and the easiest and quickest way to answer or to respond to that is we simply just refer to the cliche, right? The old cliche that says an ounce of prevention is worth a pound of cure, which of course means that if we could prevent, pollution from happening, then we need not do a whole lot in controlling it. We don't have to control and do any kind of controlling or much controlling later on. I say we would have prevented what we would otherwise have to control later on. Okay. Now, this statement doesn't mean that all efforts in controlling it is going to stop and all those energies would be redirected to pollution prevention. That's not what this means. I don't think so anyway. It means that yun ang tututukan, that would be the focus, is pollution prevention, while continuing to do whatever is necessary in controlling air pollution. And I say this because if you look at the law, yung sentence that discusses this really says something to the effect that the focus should be on pollution prevention in place of control. Parang ganyan. So it almost sounds like don't control, but do this instead. Parang ganyan. Okay? But that's not what it means. It just means that our primary focus should be in prevention, but controlling pollution should still be part of the effort. Next, implemented through proper delegation and effective coordination. We're still, at this point, we're still talking about the holistic national program. So it's this means of implementing it continues to refer to the holistic national program. I think to better explain what this is, let's first talk about who is mandated to be the lead agency on this matter. It's actually the DENR, the Department of Environment and Natural Resources, through their line bureau, the EMB, the Environment Management Bureau. Okay, and they are imbued with the authority and the functions to do these things, to implement what's on this law. Okay, there may be cases where there is a need to tap as a multiple or a force multiplier. There may be a need to tap as a force multiplier a government agency or an instrumentality of the government for some of this function. And since the DENR is the one that is mandated and thus imbued with the authority to conduct those functions, in order for them to delegate, it would have to be done properly. And the proper delegation employed today is through deputation, meaning they deputize the respective agency or instrumentality such that they would be given the authority to essentially do those functions. Okay, so the proper delegation that is being referred to here, actually the being able to deputize the agency, that deputation process, deputization process, is what this proper delegation is really referring to. It's delegation, but it's made proper because it's the formal process of delegating that responsibility to that agency. Okay. Now there may be cases where an agency already has functions that are inherently theirs, so they don't need to actually be delegated that function from the DENR. All that is necessary would essentially be to coordinate between that agency and DENR so that they could be in harmony towards attaining their same intended goals, okay, of controlling air pollution. So that's what that bullet point is: implemented through proper delegation and effective coordination. Next is, okay, this bullet point. Let's talk about industries first. I think we have at this point an idea that many industries are the culprit to air pollution. Readily evident. In fact, this slide that you're looking at right now, the background is that of a kind of a manufacturing plant, and there's actual parang pipes that are pointing up to the sky, and those pipes are outlets for smoke. You know, the parang byproduct of whatever this company is manufacturing. So yung mga sinusunog nila, you know, it basically it creates smoke that goes out through these pipes. Okay, so yung mga industries na ganyan, you know, industries that cause this pollution, and there's quite a good number of those that do that. Okay, there's a need for them to cooperate. Okay, and not just them. As we said earlier, each one of us, you know, are, you know, using this resource, you know, without having to consciously decide if we're going to use it or not. Okay, we're using this resource, and we are also contributing to the air pollution. Okay, so much the same that industries need to cooperate, there's also a need for every citizen to cooperate. And again, as consumers of this resource, we, you know, never had any kind of training on its use, and naturally there's also correspondingly no training on how to prevent pollution. We just by nature use and pollute without really knowing sometimes what we're doing. So if there's a need for cooperation, but not limited to cooperation, there is need for self-regulation. You know, that we need to police ourselves. Okay, we need to have some conscious effort of contributing to the, you know, the need to control air pollution. So that's what this is all about. Last on this list is promote public information and education in air quality planning and monitoring. So this really speaks to what I just described moments ago as to our lack of understanding sometimes of the use and misuse of this resource. Okay, again, we were born not having to be taught how to use it, so it's also not common for us to be trained on how not to abuse it or how not to pollute the air. Okay, so there is that need, okay, to be informed and be educated. And you know, actually this is not a completely new concept. I think in the last several years, maybe in the last 10 years or so, there's been some consciousness about pollution, probably more than 10 years. I'd say maybe about 20, possibly even 30 years. You know, there's already a public consciousness about pollution. So, you know, we've as a people have learned, have been informed and educated such that the generation today is much more conscious. Lalo na yung mga millennials, they're more environmental conscious. They recycle, things like that. So, and those are all byproducts of public information and education. Okay, so this bullet point just talks about the continuation, the continuing need to do that. You know, because this is you know, this is an ongoing thing. It's, you know, things change, so there may be needs about informing. There may be a need to inform people about what those changes are, things like that. So this is an ongoing activity as part of this comprehensive air pollution control policy. Okay. So as a policy, this Clean Air Act of 1999 describes the requirements for a comprehensive air quality / pollution management and control, and organizes these requirements into 3 areas. Okay, And the first area is air quality management system, followed by specification setting, or really it's a standard setting process, okay, that involves setting specifications. And then the third one is institutional mechanism. So we're going to talk briefly about each one of them. Let's start with the first one, air quality management system. Okay, in air quality management system, this system is actually centered, okay, or at least it's at the core of this system is this air quality action plan that we're going to talk about in a minute, okay? This air quality action plan actually is a byproduct, an output, if you will, of the efforts in a framework that's created specifically for this purpose. That framework is what they refer to as the Integrated Air Quality Improvement Framework, okay? That framework is something that just doesn't happen either. It's based on something else. And this something else is a status report that's done at the national level. So it encompasses the entire country, okay? It's a national air quality status report conducted by the DENR every year. So those outputs are the basis for the creation, which, and of course, this was this framework already exists. But the law at the time that it was created was talking about the creation of a framework, and that's based on these reports. So anyway, this framework, there is one now that was in essence responsible for the latest air quality action plan. What I have on the screen is a picture of a draft. I think there's one that's been no longer a draft. There's an actual formal one that was published sometime in 2017, 2018 timeframe. So anyway, this air quality action plan is what came out of the integrated air quality improvement framework, which of course was based on national air quality status reports that are done annually by DENR. Okay, so that's just how it kind of evolved. But let's now focus in on exactly what, in a summary, exactly what this air quality action plan is. Okay, bottom line is ano siya, blueprint siya. It's really a blueprint. Okay, it's really just a blueprint, an official blueprint that all government agencies must comply with. Okay, specifically so they can attain and maintain clean and healthy air. So any government entity that has some responsibility in compliance, as well as being able to attain these conditions, these air quality conditions, okay, are supposed to follow or use this as a baseline for their efforts. Okay, so there's a number of things that it does, and I'm just going to identify a few just to kind of give you an idea of what's in this action plan. It provides for limitations on emissions. Okay, so as I'm sure you know, emissions, yan yung ini-emit, nilalabas, binubuga, kumbaga, right? Technically, all of us humans also emit. Every time that we breathe out, we're breathing out carbon dioxide, so we're kind of emitting that, right? But this doesn't apply to that. It really applies to, for example, industries or mechanisms, or machines, not mechanisms, but machines, engines, or anything that produces, or emits, something that is a pollutant, namely carbon. Okay, so this action plan creates those limits and provides for their enforcement. Okay, and so the enforcement that it provides is actually based on provisions that prohibit, adequate provisions that provide the prohibitions on, pretty much, prohibiting particular sources of these emissions, as well as types of emission activities. Okay, so it's not limited to the sources, to a particular source, but even on the types of emission activities. Okay. Now, the other thing that is included in this enforceable emission limitation, at least in these provisions, are other control measures, means or techniques, including schedules and timetables for compliance. So in other words, when this action plan comes out or came out, and let's say, for example, there's something there that says you have to be doing this, okay? And there's an existing company that isn't doing this, okay? What is that company to do? Is it now required to stop its operations? No. What the action plan provides basically is it provides for some time for these entities to comply. So it creates a timetable, a realistic timetable, so that they're not having to stop their operations. Okay, so that's what we're talking about as to control measures. Okay, what else? Okay, well, we already actually talked about control measures, but this one is as it relates to how this action plan actually enables entities, organizations, and whatnot to be able to comply. Okay, so some of these enabling things that it provides are incentives, right? Incentives, that would empower, for example, an organization to move faster, so they can meet those requirements. Maybe tax incentives or whatever, whatever it would take. And of course, these incentives have to be cost effective. And what that means is whatever cost the government would incur in offering those incentives, okay, the results should be commensurate with that. We're trying to get these guys to comply with their emission limits. Say they're polluting the air, so we want them to kind of stay within control, and we want them to comply. So if they do comply based on an incentive that's offered, whatever the cost is to the government in offering that incentive, then the result, the compliance by that organization, should be commensurate. It shouldn't cost more. The cost of the incentive shouldn't cost more. So really, that's what we're talking about when we say cost effective. Okay. So all right, what else? Okay, so syempre, there is mention of education and information. That's an integral part of the effort here. Okay. So another thing that we would find on this action plan is some discussion about designating airsheds. Okay. All right. So airsheds. What exactly are these? This could be a long discussion, so we'll just try to be brief about this. Airshed really are they're areas with a common characteristic. Essentially, they refer to areas that they have a common weather pattern, and the conditions there are pretty much the same, the meteorological conditions, and thus the sources of pollution, are also pretty much the same. The sources could be from particular industries that are concentrated in that given area. So basically, all of that interchange or diffusion of pollution are all kind of consistent, in that area. And the easiest way to sort of make sense at a high level as to what we would find in this airshed is that basically they have similar qualities, as I sort of implied a minute ago, And being that that's the case, where there's this interchange of pollution that's common, they face the same or similar problems. And thus, the programs that would need to be developed for them, solutions, that sort of thing, would also be consistent. Okay, so that's, so they kind of are a big factor in efficiently coming up with a means to control air pollution in those given areas. Now, in the Philippines, there are 22 so far. Out of 20, as of 2018, there are I believe 22 designated airsheds. But that's not a static thing. Siyempre, the conditions on Earth change, and there's new areas that are being developed that may affect many of the conditions that could potentially create new airsheds. So the effort to designate airsheds is kind of an ongoing activity. So this action plan provides for the means. It sort of comes, suggests the rules, the criteria, that sort of thing, so that airsheds could be effectively designated. Okay, I hope that makes a little bit of sense. It's a kind of a long discussion, so we don't want to get too far into it, but I think, and I'm hoping anyway, that kind of at least gives you an idea of the importance of airsheds. Okay, so let's move forward. What else do we have here? Okay, the one thing I want to mention among the many provisions or many things that we find in an action plan is that if ever there is any case or instance where the action plan does not cover it, then there is this provision within that action plan that is to serve as a parang catch-all, So essentially anything that meets the criteria, and the criteria, of course, is that it's necessary for the effective control and abatement of air pollution. So, if there's a thing that's not an activity or a measure that's not already on the action plan, but that activity or measure necessarily helps or is necessary for the effective control and abatement of air pollution, then it is essentially covered by this law already, because this provision kind of covers everything else that is not specifically covered. Okay, so I mean, the one reason why I put that in here is the idea kasi is that this needs to be comprehensive, diba? Kaya nga, it needs to be, it's a comprehensive policy, so naturally all of the requirements to ensure that everything in the policy is met, naturally it has to be all-encompassing then. So that's why they have this, as an example, this is a provision that if there's anything that's missed, in this action plan, that, it's covered, that it's allowed, so to speak, or that it is allowed in the action plan, thus allowed in the law. Okay, so I hope that makes sense. So let's now move forward. I think at this point we can shift gears and move to the second category of requirements on how this law provides, and that's in the area of specifications setting. And as I said earlier, this is more of a standard setting process. It's a process of setting standards from which rules or guidelines are to be based. Okay? So the idea here really is to put some controls over a number of things, namely fuels and additives. Okay? Yun talaga yung focus nito, is on fuels and additives. Okay? And the goal is to be able to ensure that emission is reduced. And as we know, many of these additives, you see this picture up on the screen, they're different products that are supposed to improve the performance of your car, and so on and so forth. So there are things that are added to the fuel to essentially improve perhaps the performance of the vehicle. But there are consequences which, if not properly regulated, could actually cause more harmful emissions more than the benefit that you gain out of it. So there's a need to regulate that. There's a need to control that. There's a need to oversee and set standards that people would follow, so they're not, causing unnecessary pollutants in the air. Okay, so what we find in these provisions of law, of this law, is one that talks about, again, setting the specifications. And as I said, this is for fuels and fuel-related products, the additives. Okay, and we also find in these provisions, that it provides for allowable content of additives. It sets the limits on how much of this particular compound needs to be in there, that sort of thing. Okay, and just to kind of give us a good sense of how these two kind of are put into place, let me show you how the law provides for this. Okay, and this is actually the language in the law. Okay, essentially it is talking about unleaded premium gasoline, that in order for it to be allowed for commercial use, okay, it has to meet certain conditions. Okay, that it has to have an anti-knock index, or AKI, of not less than 87.5 and reed vapor pressure of not more than 9 psi. Okay, very technical. I mean, for us that are not, in this in the petroleum industry, I mean, those things may not make sense to us. But bottom line is, those are the limits, those are the specifications, those are the standards, right? That says, in order for this type of gasoline, this unleaded premium gasoline, in order for it to be allowed for use, for manufacture, for import, for sales, supply, offer for sale, dispense, transport, or in any other way introduced into into commerce, okay, it must meet those conditions. It must meet that specification. Okay, so this is an example of what we're talking about as to setting expectations and even specifying the allowable contents of particular additives. Okay, so that's an example. Okay, what else might we find in this area, in this category within the law? Okay, it talks about regulating the use of any fuel or fuel additive. And okay, so when we say regulate in this context, and actually even in earlier laws it was in the same context, when regulate is used, when the word regulate is used, there is obviously need for permission or licensing. Okay, so so that's what this is really talking about, right? Is essentially in order for particular additives and fuels to be introduced into commerce, such fuel or additive has to be registered. Okay, hindi basta-bastang, porket it's already complying to the specifications, you could already introduce it into the marketplace. No, it has to be registered. So, and this applies to, manufacturers, processors, and traders. So, before they could, introduce what they've manufactured, before they can, introduce what they've processed or trade, okay, whatever it is that they're manufacturing, processing, or trading, okay, before that could be introduced into the marketplace, okay, it needs to be registered. Okay, that's what regulating here is referring to. And the earlier laws that we covered, we were talking about permits and licenses. Okay, so here it's talking about registering. All right. Okay, now there's something I want to share just to kind of make sense of these regulating activities. It's not completely related to this thing that we're just talking about just now, but you can probably relate to this. This is I just want to show you a picture. This is something that, of course, we see here in the Philippines. The one on the right side, that's a commonplace kasi we live in Metro Manila, so we see a lot of those almost in every corner. Regular gas stations. This one is a picture of what looks to be like a Shell station. Siyempre, we could see that they're it's very likely that they're in compliance with all of what the law says they're supposed to be doing. Say you can see a number of things that indicate that, like there's nakapaskil, there's things that says, for example, the octane grading, okay, and then there's some signs that talk about what you can and cannot do while you're in the premises of the gas station. Of course, there's a price list, and not to mention, yung business permit nila nakapaskil sa pader, right? Very visible. So, those things kind of tell us that these guys are, legit, right? And as an investigator, it probably wouldn't draw any suspicion as to whether, these guys are conducting business involving fuel and fuel additives. It wouldn't seem like they would be doing anything unlawful. However, if you look on the left side, that's also commonplace. We see that a lot in the provinces. Diba, when in the rural areas we're driving. In fact, the first time I saw those, I thought they were selling some kind of juice kasi medyo red, diba? Gasolina pala yun. So, anyway, I just wanted to throw that out your way. And as an investigator, syempre, these are just pretty obvious things that would probably give you the right, what's the right word? The right kilite, if you will, or the right instincts to tell you that, siguro I need to focus more on the people on the left as a possible violator of this law. So anyway, so that's that. I just wanted to share that real quickly. All right, so let's move on. So the last point in this grouping refers to a prohibition on the manufacture, the importation, and sale of a type or a particular gasoline. As well, the prohibition on the engines and or components that would use that, okay, that use that type of gasoline. The gasoline I'm referring to here really is leaded gasoline. So the prohibition is in the manufacture, import, and sale of leaded gasoline. Just the same, the prohibition against manufacture, importation, and sale of engines and or components that actually require leaded gasoline. So that's where the prohibition is. Okay. Now there's a couple of important reminders come out of this discussion on leaded gasoline. First, I don't know if it's something that you remember or know about. If you're a millennial, you may not remember leaded gasoline. But anyway, it used to be, when you'd go to a gas station, unlike today, when you go to a gas station today, you have two general types of gasoline that is available for you, right? It's either unleaded or diesel, depending on the type of car or vehicle that you're using, right? And the only other options would be, if you're selecting unleaded, it's either the 91 or 95. And depending on the gasoline station you go to, they may refer to it. They may have different names for it, like premium, whatever, right? But anyway, in some years ago, at least up until I believe the year 2000, okay, it used to be leaded. There used to be a type of gasoline called leaded, the same one that we're talking about. Okay, and as the name implies, it had lead in it. Okay, unlike unleaded, there's no lead in it. And it was over time, I guess, it was discovered that lead, when it burns, because this is fossil fuel, so we're generating carbon monoxide, pollutants in the air. But particularly if the gasoline type was leaded, it was apparently worse for the environment. The effect was greater. So there was a need to eventually phase that out and prohibit it altogether. It couldn't be stopped dead on its tracks because cars were made so that they would use leaded gasoline, and of course many depended on it. There was industries, the petroleum industries, that a big bulk of their sales was on leaded. So, this clearly wasn't something that could just be prohibited, and from that point forward of its effectivity of the prohibition, that everybody would just stop using it. It couldn't be done that way. It didn't make economic sense or any sense, period. Okay, so there was a need to phase that out. So this kind of goes back to our earlier discussion about timetables for compliance. This is actually a great example of that. In situations like that of leaded gasoline, it wasn't something that couldn't just be stopped right then and there and prohibit from that point forward. It had to be slowly, over time. It had to be phased out in such a way that it wouldn't have a dramatic impact on industries and whatnot that depended on this type of fuel. All right. So anyway, that's something I just wanted to add about that. But anyway, to this day, as I said, based on this last bullet point, you should not find any more leaded gasoline in circulation or available for sale. In fact, there probably wouldn't even be any engines anyway that would be able to effectively run on leaded gasoline. Okay, so that's that. On institutional mechanism, the law provides, first and foremost, that the lead agency for this law, or at least the agency that would be responsible for the implementation of this law, is the Department of Environment and Natural Resources, DENR. Okay. Interestingly, this law also specifically mandates that the agency or the bureau under the DENR, the bureau called Environmental Management Bureau, the law specifically converts it from a staff bureau into a line bureau. Okay, and although there's a period that there's a duration for that designation as a line bureau, but the purpose, of course, is so that EMB, the Environmental Management Bureau, okay, the purpose is for that agency or that bureau of DENR to be empowered, or to essentially be the agent, if you will, of DENR, serving as, of course, being the DENR as the lead agency. So the EMB, the Environmental Management Bureau, would be the bureau under DENR that would be responsible for implementing this law. Okay, so in addition to DENR, the law also provides that there is some linkages, some mechanism for linking up with other bodies, government bodies, and even non-government agencies, as well as people's organizations. Okay, so the law, the specific provision says that that the department, in this case DENR, through EMB, shall consult, participate, cooperate, and enter into agreement with other government agencies or with affected non-governmental or people's organizations, or even private enterprises in the furtherance of the objectives of this act. So again, DENR as the lead agency, through its line bureau EMB, they are to also link up with pertinent government, non-government agencies, as well as people's organizations, and even the private enterprise, in order to further the objectives of this law. Okay, so besides the two that I've already mentioned, there's also a definite need to involve the local government unit. And when we're talking about the local government unit, we're talking about the province, and the local executive there, of course, is the governor. We're talking about the city or municipality. In those two cases, the local executive there is the mayor, and quite possibly even the barangays. Okay, because that's what that's what is included in local government units. Okay, so the responsibility of local government units is that they are to share in managing and maintaining air quality within their territorial jurisdiction. Okay, and so they're having to follow the earlier framework that I mentioned, the integrated framework, and of course the action plan that came out of it. That's their, as I said earlier, it's their blueprint. So they're going to have to sort of follow that and implement accordingly, and specifically to their jurisdiction. Okay, so that means for the governor, it would be, of course, the province that he or she governs, and for the mayor of either the municipality or the city, it would obviously be the city or municipality, and so on and so forth. Okay, so the other point that needs to be made here is that the LGUs will not be on their own, even if the law mandates them to take part in this activity of controlling, or this mandate of controlling air pollution. They are provided some assistance by the DENR. Okay, if you look at the second paragraph, it says that DENR, that says the department, but of course they're referring to the DENR through EMB, shall provide the local government units with technical assistance, trainings, and a continuing capacity building program to prepare them to undertake full administration of the air quality management and regulation within their territorial jurisdiction. So they have a mandate to follow what's on the action plan and to implement, regulate all the pertinent activities that the law requires. So they have a mandate to do all of those things specific to their jurisdiction, but they're not on their own. They are given some assistance by the DENR. Okay, let's move forward. So some last words before we move on to the next topic. Since we were talking about the leaded gasoline and also the phasing out approach, that there's a timetable that is provided, I think it's also worthwhile mentioning that the law, the Clean Air Act, has provisions about quotas, emission quotas, as well as emission trading. Conceptually speaking, let me just provide a quick explanation, as easy as I can make it. Okay, when we're talking about quotas, emission quotas, those are cases. Well, actually, there are quotas that are set, obviously, and they're usually based on a given airshed area. So if you have let's say, for example, an area that has industries. So given the area that they're in, there's usually like a set standard on how much emission is allowed. So that standard, in essence, is the quota that we're referring to when we said emission quotas. Okay, so naturally that means industries are not supposed to go beyond that quota. Okay. But just to make it so they're not completely in a situation where they appear like bad guys, the way things have been put together, and this is not just in the Philippines, by the way, what the Philippines put together, itong quota and trading, is actually based on international standards. Okay, so if you have industries in a given airshed, there's given a quota on the amount of emission that they're supposed to produce. If, say, for example, one of the industries is producing less than the quota, okay, let's just, for the sake of discussion, we're not going to get too technical here, but let's just say that the quota is at 100, okay, and one particular industry or manufacturing plant is producing much less than that. Again, these are just for the sake of discussion, so we can make sense of it. Let's say that entity is producing much less than the quota. Let's say 80, because we said that the quota for this example is 100, but this entity is only producing emissions at 80. Okay, so that means they're under the quota, right? You have another entity that is producing more than 100, let's say 120. So they're technically, if you think about it, they're in violation. No, they're exceeding. Okay, what they can actually do is they can actually trade the entity that is under the quota could sell the amount, the difference between what he is actually emitting versus what the quota is. Let's call those credits. So he can actually sell those credits to the other entity who is in excess of the quota. So yun, that's kind of how it works. It's, they made it sort of into like a business, and the good news, of course, is that it gives people a solution, gives entities a solution when they're confronted with those cases, while at the same time, we're maintaining levels so that we're not continuing to, cause climate change, to increase that gaping hole in our atmosphere, because all of these standards are actually intended, to prevent those things, right? And the good thing with this trading is that just because one entity is exceeding those standards, and he's able to trade with somebody who's not, it sort of balances out. Kasi whatever excess the entity incurs, whatever his overage is, okay, even if he's continuing to have those overages, for as long as he offsets by trading with someone who is, under the quota, okay, for the amount, the amount that entity is under quota is equivalent to the amount that the other person is over quota, go offset. So as long as there's that mechanism which this trading allows, then it balances out. Okay. So yun. So those are also features available on or at least features that are made available in this law. So now that can be done here in the Philippines. Okay. So let's move forward now. Let's go ahead and proceed to the next topic, which would be on punishable acts. So on punishable acts, the Clean Water Act presents things similarly to the last law that we discussed, the Laguna Lake Development Authority Act. Okay, it presents them unlike the earlier laws where you had a specific line item that already provides the elements of the offense, right? For this one, let me just quickly show you. It is actually referring to other sources, okay? So if we read this, let's focus in on subparagraphs A and B. So for subparagraph A, essentially what it's saying is that for violations of standards or limitations that are provided in this act itself, in this Clean Water Act itself, it's referring to those violations. So that, of course, means as an investigator who is trying to determine the elements of the offense, kailangan i-research mo muna sa batas na to. Specifically, you'll have to look at all of the standards that this law set and identify from those standards that it set which appears to be the standard that was violated in your case. Okay? And once you've determined that, then you home in on that specific provision to see what elements of the crime or of the unlawful act there is. Okay? So moving forward, the second item here, subparagraph B, refers to another source for those offenses. And this one, it's referring to any order, rule, or regulation that is issued by the DENR with respect to such standard or limitation. So essentially, as it relates to these standards and limitations, if there are any issuances, namely an order, a rule, or a regulation that is issued by the Department of Environment and Natural Resources, then you'd have to refer to those issuances. maybe resolutions like LLDA in the LLDA, or generally kasi sa DENR, they're not resolutions, but rather they're Department Administrative Orders, so DAOs. Okay, so that's that's where you'll likely find those that fall under this subparagraph. Okay, now I did pull up just because I thought we would do some exercises under subparagraph A. But before we do that, let me just let's just go over real quickly the first paragraph of section 40. It's entitled Administrative Action kasi anything, well, generally speaking anyway, the unlawful acts here are administrative cases. That of course means there is no jail time. It's usually a fine, okay, or some kind of a penalty involving payment of fees or something like to those something to that effect, okay, but no jail time generally speaking. There are instances where criminal cases may be filed, but there are exceptions. So, and we'll talk a little bit about that when we talk about the quasi-judicial body where these administrative cases are filed. Okay, so anyway, so the first paragraph also just talks about who would be the persons that can initiate, that can institute these administrative cases, and all it's really saying is that it can be instituted by any person, okay, and or by the DENR themselves at their instance, or upon a complaint by another person, by any person. Okay, so that's all that says there. Okay, it just talks about who would essentially institute this administrative action. All right, so I hope that's clear. Let's move forward. Let's take a look at the examples under subparagraph A. So I pulled a couple of cases, or at least provisions, and two of them actually are very much related to the last thing that we were talking about leaded gasoline. So let's go ahead and pull that up real quick. So section 29, title is Prohibition on Manufacture, Import, and Sale of Leaded Gasoline and of engines and/or components requiring leaded gasoline. This is actually the same provision that we cited in the last topic. Okay, and let's just read it. We can skip through this effective not later than 18. I mean, essentially, it's effective now because this was really referring to the times shortly after this law was put into effect back in whenever that was in 1999. Okay, so these are already in effect. So the basically the act here. Well, let's start with the possible offender. So in reading it, it says that no person. Okay, so no person. So it's talking about any person. Okay, and the act really is that of manufacturing, importing, selling, offering for sale, introduce into commerce, convey or otherwise dispose of in any manner leaded gasoline and engines and components requiring the use of leaded gasoline. So there you have it. There is no qualifier. So if we put it on our worksheet, it looks like that. Okay, any person, and then act or emission is all of those things that followed: manufacture, import, sell, offer, etc., etc. Okay. The second one I also chose for this demonstration also speaks to leaded gasoline. Let's go ahead and look it up. Section 28. It's referring to, it's entitled misfueling. And it starts on the second half of the first sentence. It says, no person shall introduce or cause or allow the introduction of leaded gasoline into any motor vehicle equipped with a gasoline tank filter inlet and labeled quote-unquote unleaded gasoline only. This prohibition shall also apply to any person who knows or should know that such vehicle is designed solely for the use of unleaded gasoline. So, madali lang din ito. This is how it would look on our worksheet. Okay, possible offender is any person, and the act or omission is essentially everything else that I read after no person shall. Okay, so it's introduce or cause or allow the introduction of leaded gasoline, and so on and so forth. So you should know this by now. Medyo siguro na master niyo na to. So the third thing I want to show, this one is a little bit more. It's a combination of more complicated, but more conclusive, I would say. Okay, and this is a standard that's set in one of the provisions. Okay, it's talking about instances with respect to any trade, industry, process, and fuel burning equipment or industrial plant entitling air pollution, or sorry, emitting, not entitling, emitting air pollution, air pollutants. Okay, and basically these are the standards that it's talking about. It's talking about as it relates to a particular pollutant. Like the first column refers to the pollutant. So if you look at the first row of that first column, it's the first pollutant identified there is antimony and its compounds. Okay, so and it's talking about sources, and then the specific limit, the condition as to what is permissible, to what extent it is permissible, and then your method of analysis, in essence, how you concluded if what you are looking into actually complies with that standard. Okay, so this would imply that you would have the tools for this. So the good thing about that is the tools will tell you. It's a little bit more conclusive. Maybe you would just need to document your process just to make sure that if you're having to qualify how you collected or how you came up with that conclusion, you could talk about how you did it. So maybe there's that necessity of documenting it. But for the most part, if you're able to prove that you did collect that information correctly, okay, that you used the tool that's necessary to produce this analysis correctly, okay, basically it would just boil down to looking at the results that are produced by that tool, that equipment that you use. Okay, and that in itself should technically be conclusive. I mean, they may challenge. There may be a challenge against how you use that tool. So again, as long as you're able to prove that you used it according to the instructions, that the machine is working, it's functioning properly, thus the results that it produces are accurate. Okay, so yun lang. So it's a little easier in that basta pinroduce na ng tool yan, the output, it's that's there it is, right? You probably wouldn't need to do any more investigation or anything like that. Okay, besides it's generally administrative cases naman so the standards are lower, so it wouldn't require, as an investigator, you wouldn't be doing anything heavier. But anyway, for these types of analysis, there's usually already facilities provided. Like for example, when it comes to cars, the emissions of cars, naturally there's emission centers, emission testing centers to determine, to essentially produce this analysis. Okay, so all right. So anyway, moving forward, at least this gives you examples of how the punishable acts are presented in the law, and of course, since they're administrative cases, the standards are lower. There's no jail time, generally speaking. It's just a fine or some type of citation with some penalty. So yun, that's kind of how this law presents those um, unlawful acts. Okay. Now I mentioned earlier the pollution, um, the pollution adjudication board. Okay. The pollution adjudication board is, because this is an administrative case, the body that you would be filing this case to, it wouldn't be the courts. It would be a not a judicial body, but a quasi-judicial body. And that quasi-judicial body is the PAB, the Pollution Adjudication Board. Okay, the PAB was actually created. You might recall in an earlier discussion that there's an executive order that was put into effect, which reorganized the DENR. So one of the things that it did in its reorganizing is it created this quasi-judicial body, the Pollution Adjudication Board. And of course, its purpose is for the adjudication of pollution cases. Quasi-judicial body. Okay. There's another instance where the PAB's jurisdiction was expanded, and in fact, the Clean Water Act, this specific act, there's a provision in there that expanded, well, actually, that made it. Okay, so the PAB is, sorry, this wasn't in the Clean Water. It's actually on the under the revised rules and procedures. Okay, the revised rules and procedures. That's the source as to what made it so the jurisdiction of the PAB now covers also the Philippine Clean Air Act as well as the Clean Water Act, the same laws that we're talking about now. Okay, so yun. Anyway, so yun, this is where you would file the cases, and they're the ones that make the determination as to whether there is indeed a violation or not. Okay, a finding of violation or not. Okay, so I think that is it. We are done with Clean Air Act, so we should now move to the Clean Water Act. All right, so now let's talk about the Clean Water Act. So what is this law all about? Okay. In essence, it is about protecting water bodies from pollution. So it's not too different from the Clean Air Act. Excuse me. The law also provides for a comprehensive water quality management. And of course, that's in its objective of protecting water bodies from pollution. Okay. Now, this comprehensive water quality management naturally provides a description of the requirements so that it can achieve its goal of protecting water bodies from pollution. So that's something that we will discuss when we look to answer how does it provide. But before we jump in to answer that, let's just dig a little deeper and get a little bit more information about what is involved in protecting water bodies from pollution, and as well, the comprehensive water quality management. What else is involved with that? All right, so let's take a look at a couple of slides that discuss that briefly. All right, so the first one is on the protecting water bodies from pollution. Okay, this actually qualifies that the act of protecting, or that objective of protecting water bodies from pollution, is not, it's not a complete sentence. Basically, there's a qualifier that the pollution that it is referring to here is that from land-based sources. Okay, kasi we're talking about pollution into water bodies, right? So for this objective, when we talk about pollution, it is qualifying that that pollution is something that comes from sources not on the water but land-based. Okay, So that's an important qualifier. Now, on the comprehensive water quality management, um, besides having that, there is also an integrated strategy that aims to prevent and minimize pollution, which involves a multi-sectoral and participatory approach involving all the stakeholders. And we'll talk a little bit about that when we get into the institutional mechanism that is provided by this law. All right. So, okay, so that gives us a little bit more depth about this, what this law is about protecting water bodies from pollution, and also a little bit about the comprehensive water quality management. Okay. But before we dive into, how this law provides, how it describes the requirements for this comprehensive water quality management, it would probably be a good idea to just quickly go over the provision of this law that talks about the coverage of this act. Okay, so I pulled this from the law itself, and basically it says that the coverage, okay, applies to water quality management in all water bodies. Okay, all water bodies throughout the country. Okay, so besides pollution from land-based sources, it is also talking, as part of the scope, it's also talking about application, primarily the application of the abatement and control of that land-based pollution. Okay, so that's part of the coverage. I think an important point of mention, also as it relates to penal provisions as well as civil liability, is that even if the source of the pollution is said to be land-based, okay, insofar as penal provisions and civil liability is concerned, it actually doesn't matter if the pollution does not come from land-based sources. Okay, that's what it says here. So, when it talks about a particular offense, when it talks about the elements of that offense, okay, we have to take into account that when it is referring to the body of water as that having been polluted, the pollution, insofar as those penalties are concerned, or the definition of that offense is concerned, that pollution it's not necessary that it came from land-based sources. Okay, so essentially that's what this is saying here. All right, so I think that should give us enough to answer, hopefully more than enough to answer what this law is about. So let us now proceed on. So now let's talk about how this law provides. How does it provide such that it meets the objective of protecting water bodies from pollution? Okay, just a quick point. This is going to be a relatively quick discussion, only because everything that is on the Clean Water Act is not that different from the Clean Air Act in terms of the particular requirements the law has set in order to deliver on its objectives. Okay, so we'll just breeze through it and sort of identify what are possibly unique about them or things that are worthwhile mentioning. Okay, so with that, let us proceed. All right, so like the Clean Air Act, it is also comprising of a water quality management system. Of course, the Clean Air Act was an air quality management system. So it's a system that is also based on a number of similar things, or actually almost identical things to that in the Clean Air Act. Okay, but first of all, let's take a look at some of the bullet points that are worthwhile mentioning about the water quality management system. Okay, so first, it refers to a management areas. It's talking about management areas. Okay, when really this is the scope of this water quality management system. Management areas that are designated as such. Yeah, we're talking about water quality management areas, which are designated as such, and it's not just one that's designated in the Philippines. There are, a number of them, and their designation is based on, common factors in that given area. Usually, something that's based on a watershed, and of course, in the case of clean area, would have been, in this case, it may also play in, and I'm talking about airsheds, of course. Okay. So multiple designated water quality management areas. Okay, so let's see if there's anything. Let me just quickly look at my notes to see if there's anything in there I have to mention. Okay, I already said that they share common characteristics. Okay, like geographic conditions, that sort of thing. All right. And they may also share common interests or phase, and basically things that would make it so programs, development programs, and even problems are the same for that water quality management area. Okay, so they're just groupings. Okay, so with these management areas, there is a governing body. Okay, there is one for each of these management areas, water quality management areas. Okay, and they are composed of a number of key players in government. Okay, and even NGOs as well as people's organizations. So you have, for example, representatives from the local executives, the mayors of cities or municipalities, or governors of provinces, including local government, the smaller local government units, meaning the barangay captains. That's those sorts of representatives. Okay, I mentioned there's also participation of non-government organizations, the NGOs. Okay, as well as concerned water utility sector and business sector. So they are not necessarily part of the government, but they are, because of their focus area, the fact that they're in this sector, they are also an important participant, an important player in these governing boards. Okay, so let's move on. Okay, the other things worth mentioning about this water quality management system is that it also covers programs, national programs on sewerage and septage management. So that's, the sewage system and the septic tank, the septic systems, those things are also covered under this water quality management system. Okay. All right. So the other things worthwhile mentioning is that it regulates wastewater discharges. Okay. So this is when there is something that needs to be discharged, and generally because they're fluids, it probably makes sense to, or at least maybe convenient or whatever reason, but there is a need to discharge them into the body of water, a body of water that this law protects from pollution. Okay, so naturally there's certain conditions that have to be met, certain qualities, I suppose, in order for discharges to be allowed, and in order to be able to determine if what is proposed to be discharged meets those conditions, there must naturally be a process of regulating it, and that process involves obtaining permits. The more common well, they're called discharge permits. Okay, so that's one way that describes exactly how it's regulated. Okay, and like the other permits that we've discussed before, these permits are undertakings, agreements really, that makes it so the permittee understands exactly what his obligations are, what the limits of his licenses are, what the terms are of his license or permit, and that he undertakes to abide by those terms and conditions. Okay, because that is what the permit permits. Okay, so he has to remain within the confines of the permit. All right, so that is regulate wastewater discharges. Okay, there is also coverage for effluent trading per management area. And this trading is almost the same. Actually, it's technically the same, but they're not talking about the same exact thing that's to be traded. It's just, and I'm referring to the emission trading that we talked about when we were talking about the Clean Air Act. You might recall my last points that the Clean Air Act provided for that. There's quotas, and that if there are people that are not meeting those emission quotas, they are essentially under the quota, so they have credits that they can sell to others who are, who have exceeded those quotas. So same thing here, but instead of emissions, of course, we're talking about affluent trading here. Okay, so, and it's per management area. Okay, that's, I think, one key point to mention here. Okay, let's see, let's move on. Okay, there is also a reward system, which is a nice thing, I suppose. It's a good way to empower, so it's not always, the government's not always looking like a, tough body that imposes all of these limitations. So, it deviates from that persona, so to speak, to being more of a positive body by giving rewards. Okay, and the kind of rewards that it gives, are those whose wastewater discharges is better than the water quality criteria of the receiving body of water. So, in other words, if the body of water where the discharges are going to be sent to, where the water is going to be discharged to, if the water that will be discharged has a better quality than the body of water that's receiving that water, then that is warranting, or it warrants a reward for whoever it is that is looking to discharge that water. Okay, let's see, what else do we have here? Okay, so let's now proceed on and talk about the institutional mechanism. Okay, this is very similar to the Clean Air Act. I think I've mentioned that more than once already. So it's also not too different insofar as the institutional mechanism. First, the law discusses who is the lead agency to take responsibility for implementing and enforcing this law. And we know that to be the Department of Environment and Natural Resources. Okay, and this body, this government agency, as the lead agency, has a number of powers and functions. But I wanted to home in on three that were consistent with some of the very important objectives or very important requirements or means of meeting objectives of the Clean Air Act. And that's basically the action plan, the official blueprint, as I mentioned. It's the same here. There is also an action plan that is put together. It's a 10-year water quality management area action plan, and DENR is tasked to ensure that that is produced. But of course, it doesn't do it on its own. It is this action plan is something that comes as an output or as something that's based on the integrated framework, the integrated water quality management framework. Okay, again, this is also the same thing that exists in the Clean Air Act, and it's no different here in the Clean Water Act. It's something that is created and something that provides the basis for the action plan, the 10-year action plan. Okay. The integrated water quality management framework is also something that didn't just get created out of nowhere. It has its basis, and like the Clean Air Act, it is based on findings from status reports that the DENR prepares. Okay, the National Water Quality Status reports that it does on a regular basis. Okay, so let's move on. Other things about the other points under institutional mechanism. Okay, so besides the DENR, the local government also plays in. They have a role in this whole objective of protecting water bodies from pollution. Okay, they share responsibilities in managing and improving this system or the conditions, and of course this as it pertains to their area of jurisdiction. Okay, so that's their focus area. So naturally, if we're talking about a province, it would be the governor that has that responsibility, and if we're talking about a city or municipality, it would be the mayor. And likewise, the smaller units, the barangays, also play in. Okay, so let's see what else we have here. Linkages. So besides the DENR and local government, in order to fulfill the multi-sectoral body, to have this multi-sectoral body boards, there's naturally a need to involve as many in the sector as possible, not just government entities, but non-government entities as well. So in these linkages, it's not just about making contacts or anything like that, but it aims for agreements between them, since they do share in in the responsibility. They do play a role somehow in protecting the water bodies. So it only makes sense that besides linkages, that they come up with sort of agreements that would harmonize their efforts and ensure that the objective of protecting water bodies from pollution is achieved. Okay, so besides government agencies, we're talking about industrial sector as well as other concerned sectors, and of course the purpose is so that the objectives of this act could be furthered along. Okay, it's for the furtherance of the objectives of this law. Okay, so let's go ahead and proceed to acts that are punishable, or in other words, the punishable acts that are provided in this law, the Clean Water Act of 2004. All right, so let's go ahead and pull them up. I think what you're going to discover when you look at this law is that it's going to be pretty much reverting back. In other words, the way it's presented here is the same as the earlier laws that we were looking at. If you remember the earlier laws, medyo madali, because they pretty much gave you all of the definitions, all of the details that you need. Everything is there. Answers to question number 1 as to who the offender is. Number 2, which asks what is the act or omission, and if that act or omission is not by itself a crime, then we go to question 3 of asking what makes it a crime. Okay, so all of those 3 have been present in the earlier laws, and as we proceeded along, they kind of changed a little bit. They became a little tricky to determine, and even the sources as to where to find these provisions, they started disappearing from the law itself, and rather they started to defer to other sources. So in a way, the Clean Air Act was precisely that way. The specific section did not give or enumerate each and every one of the offenses, and it did not give, obviously, since it did not give that enumeration, it didn't provide any definitions. You would have to go elsewhere to find those. So anyway, for this one, it's back to easy mode because it's presented in this one section, section 27, but there is just a very, very slight twist. It doesn't give you the answer to the first question that we're asking to determine the elements, but I think that we can pretty much already conclude as to who the possible offender would be, and essentially that would be any person. So having said that, the rest of what is written on each one of these subparagraphs are the acts themselves, and on occasion, when there is one, naturally it would also provide the qualifier that would make the act an offense or an unlawful act. Okay, so with that said, I would suggest you do the same thing that I've been asking you to do, which is to do your own exercises. Look at each and every one of the prohibited acts and see if you could, on your own, like you've been doing, determine if you can extract the elements, okay, of the offense. All right, but what we'll do is we'll continue to at least two exercises just to stay in the spirit of doing this exercise. We've been doing it for all of the laws thus far, except for Clean Air Act because of the special circumstance. But nonetheless, we're gonna still we're gonna do it for the Clean Water Act. We're gonna at least for two, and then the rest, since there's quite a bit of them, I'm gonna leave them to you to play with on your own. Okay, so that said, let's take a look. Let's go ahead and focus on the first one, subparagraph A, which talks about discharging, depositing, or causing to be deposited. Now, if you read that, it would not be immediately obvious to you that there's a qualifier, okay? Because, as in the past, the qualifiers have been, actually, you know what? This one doesn't have a qualifier. I'm talking about the second one. I apologize. This one is really easy because pretty much the entire paragraph is the act itself. So there's nothing more you need to do but just to understand it. So you know exactly how to determine or look for the facts that tell you that indeed the elements coincide based on the facts. Okay, so for this one, this is dead easy. Okay, so offender is any person, and the actor or omission is pretty much the entire subparagraph itself. Okay, so very, very easy. Let's proceed to the second one. This is the one I was talking about. That's a little tricky because if you read it, it doesn't sound like it has a qualifier, but it does. And I'm referring to subparagraph D. It says disposal of potentially infectious medical waste into seawater by vessels unless the health or safety of individuals on board the vessel is threatened by a great and imminent peril. So if you read it too fast, it may not immediately catch on to it, the qualifier. But you have to just sort of read it carefully and try to make sense of it word for word, and you'll be able to determine that there is one. Okay. What makes it tricky is the act itself. The way it's presented is that it's, as a general rule, it's unlawful. That's kind of how it is presented. That's the message that it's saying. It's a general rule that disposing of potentially infectious medical waste into seawater by vessel is unlawful. That's a general rule. Unless, here's the qualifier, see? Unless the health or safety of individuals on board the vessel is threatened by a great and imminent peril. Okay? So the qualifier here is not part of the general rule, because it's starting with the word unless. Unlike the earlier ones that we worked with, where it says doing this, 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 and this without a permit. Okay, that's pretty clear that it becomes because that doing this, 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 and that by itself is not unlawful, but when you do it without a permit, then it's unlawful. But here it's sort of the other way around, because it's saying it's unlawful except or unless, that's kind of how it's phrased. All right. So that said, this is how it would look on our table, okay, on our worksheet. Okay, so the offender is any person. The act or omission would be disposal of potentially infectious medical waste into seawater by vessels. And the qualifier, of course, the general rule is it's unlawful to do that, but the qualifier is that the health or safety of the individuals on board the vessel are not threatened by a great and imminent peril. Okay, so in other words, if their health or safety of the individuals are threatened, then it would not be unlawful. Okay, in other words, like I said, general rule, it's unlawful, and it becomes not unlawful. It becomes lawful, in other words, when there are individuals on board whose health and safety are threatened by a great and imminent peril. Okay, so I hope that makes sense. Medyo confusing siya, but just read it slowly and carefully, and it will make sense. But just think in those terms. It's presented as a general rule. It's unlawful unless, parang ganyan. Okay. So anyway, so that said, I'm going to leave you with the rest of the prohibited acts for you to practice on. Hopefully you're doing that. I'm sure you are, and we've done quite a number of laws. So surely by now you are pretty versed in figuring out the elements of the offense. So anyway, I think at this point we're done with lesson 1. Yeah, hello again, and welcome back to our discussions on Brown laws. We are now ready to start with the second part of Brown laws, lesson 2, which would focus on managing solid waste. So in this lesson, we will focus on basically one law, and that law is the Solid Waste Management Act of 2000, otherwise referred to as Republic Act number 9003. All right, so with that said, let's jump right in, and let's discuss essentially the law, and we're going to look to answer 3 questions. What is this law about? How does it provide? And what are the punishable acts? So let's start with the very basic, so we have a clear understanding. Let's try to understand what this law is all about. So let's try to answer that now, okay? What is this law about? In essence, it's really all about controlling solid waste. So the law therefore provides, for an ecological solid waste management program, okay? Now, that gives us a general idea as to what this law is all about, but I think we need to just dig a little deeper just to give us a better understanding, okay, of what exactly we're referring to here when we say solid waste that needs to be controlled. What are we referring to here when we say ecological solid waste management? Okay, so let's see if we can get answers to those, follow-up questions. Let's start with defining what solid waste is. Okay, solid waste, according to the law, refers to the following. Okay, it refers to actually a number of things. It enumerates them, like commercial waste, construction debris, non-hazardous institutional and industrial waste, street sweepings, agricultural waste, waste that's discarded from household, and lastly, other non-hazardous, non-toxic solid waste. So this last one actually kind of brings up another question. Okay, what then are solid waste, or what are things that are not included in the definition of solid waste? So let's quickly look at that. All right, solid waste, what it does not include. The law talks about 3 types of waste that is not considered part of solid waste in this context. Okay, first it talks about waste identified or listed as hazardous waste of a solid, liquid, contain gaseous, or semi-solid form, which may cause or contribute to an increase in mortality, or specifically death, or in serious or incapacitating reversible illness, or acute chronic effect on the health of persons and other organisms. So it's really talking about these hazardous wastes, okay, that are known to not only make people sick, okay, not just people but organisms, okay, but it may even cause death, okay. Those types of wastes are not included in the way solid waste is defined by this law. What else? Okay, infectious waste from hospitals, okay, and it enumerates some examples of what is considered infectious waste from hospitals. So it talks about equipment, instruments, things of those sorts that are suspected to have or have been used on patients, okay, who are diagnosed with communicable diseases, okay. Like for example, COVID patients, I guess the instruments that are used on COVID patients, that's when those need to be disposed, they don't just throw them in the trash can, okay. They need to be disposed of differently, and that different means of disposable is not included in this ecological solid waste management program, okay. Some of the other things included in infectious waste from hospitals are disposable fomites that may have harbor or transmit pathogenic organisms. I mean, basically what it's referring to there is things from labs, laboratory wastes, okay. So there's a number. So essentially there's about 3 different categories that it's talking about here. But in all respects, they are all waste from hospitals, not just regular waste, but infectious waste from hospitals. Okay. So what else? Waste resulting from mining activities, which include contaminated soil and debris. Okay. So now let's proceed to define what solid waste management is. The law refers to solid waste management as that discipline associated with the control of solid waste in terms of generation, storage, collection, transfer and transport, processing, and disposal in a manner that is in accord with the best principles of a number of things: public health, economics, engineering, conservation, aesthetics, and other environmental considerations. As well, it is responsive to public attitudes. All right, so this definition, along with the earlier definition when we started to talk about what solid waste is, if you were to combine those and take from it, you are actually going to be able to define exactly what ecological solid waste management is. And in fact, that's exactly how the law defines it. It took from these 2 definitions to come up with a legal definition of what ecological solid waste management is. So let's talk about that. Okay, this is what the law says as to what ecological solid waste management is. It says it is the systemic administration of activities which provide for segregation at source, segregated transportation, storage, transfer, processing, treatment, and disposal of solid waste and all other waste management activities, very important here, which do not harm the environment. Okay, so the last sentence sort of refers back to how solid waste is just confined to those non-hazardous types of waste, right? Because the idea here, when we are talking about ecological solid waste management, is that the activity does not harm the environment. Okay, so there you have it. Now we have the definition that we need. I think at this point it's a little clearer to us as to the solid waste that needs to be controlled. It's a little clearer to us what we mean by ecological solid waste management, since again the law talks about providing for an ecological solid waste management program. So having made those conclusions, I think it's now we're now better positioned to move on to the next question of how does it provide. So let's go ahead and do that. So in this section, or this part of our discussion, we're going to look to 3 areas provided in the law that describe how this program, this ecological solid waste management program, is how it aims to deliver on its objective of controlling solid waste. So there's 3 areas, as I mentioned, in the law that are identified, and we'll look at each one of them, not in great length, but just look at them enough to understand exactly what specifically they do in relation to controlling solid waste management, okay, or controlling solid waste. All right, so the first thing that we see in this program is a section that focuses on the institutional mechanism, and then there's also a focus on the comprehensive solid waste management plan or program itself. So this is also very similar to how the earlier laws and Brown laws are put together, or at least the focus, the methods or approaches that they're taking, which necessarily includes some kind of an action plan. So it's no different here with the ecological solid waste management programs under this law. Okay, so after that, then there's some rules. Actually, they're specific to particular activities. So we'll look at each one of these activities and what rules this law provides so it can be effective at controlling solid waste. Okay, so that said, let's proceed. Let's begin to focus our attention on the first one, on institutional mechanism. So in an institutional mechanism, it really gives us an idea of all of the entities that may play in to this objective. Okay, and there are a number of them, and we'll look at the first one that's listed. It's the National Solid Waste Management Commission. Now, this commission was specifically created by this law. Okay, it reports into the Office of the President. It's kind of a who's who of participants. There are 14 heads of government agencies that are members, as well as 3 from the private sector. The government agencies, the participants, the 14 that I speak of, as I said, there are heads of the various agencies, including, DENR, the Department of Interior and Local Government, or DILG, the Department of Science and Technology, so that's DOST, Department of Public Works and Highways, okay, that's DPWH, and a whole host of others. There's DOH, DTI, and the Department of Agriculture. So there's quite a number that I won't mention. But in addition to these national government agencies, the League of Provincial Governors are also members, League of City Mayors, League of Municipal Mayors, including Association of Barangay Councils. Okay, TESDA is also among the 14 government entities, and lastly, the Philippine Information Agency. Okay, on the private sector side, there's a representative from the NGO, the non-government organization, And the purpose of that NGO is their principal purpose is to promote recycling and the protection of air and water quality. Okay, there is also representatives from the recycling industry and the manufacturing or packaging industry. Okay, so that kind of gives you an idea of how this commission is organized. Okay, so let's proceed. Let's take a look at what else is discussed here on the National Solid Waste Management Commission in terms of its organization. Okay, there's also a provision that allows it to, as necessary from time to time, to call on other concerned agencies or sectors, to partake in its efforts, again, as it may deem necessary, right? Now, in terms of its duties and functions, or powers and functions, there's a number, and let me just give you a short list. The first that I'm going to show you is one that talks about the preparation of national solid waste management framework. So very much alike, or very much like that in the earlier laws that we looked at, the under Brown laws. It's a framework that, of course, is critical in producing some of the action plans that everybody uses as a blueprint for their activities. Okay, so in this area of preparing the National Solid Waste Management Framework, they also play into approving the waste management plans that are created by the local executives. Okay, they also have a responsibility of not just reviewing, but probably more importantly, monitoring the implementation of these local solid waste management plans by local executives. Okay, so what else? They coordinate the operation of local solid waste management boards. So there's, this speaks of multiple boards, okay, that are partly involved in controlling solid waste. So this commission is the central coordinator in terms of the operation of those various boards. Okay, what else? They also provide some assistance, to local governments. So the local governments are not on their own. As well, they adopt programs and provide technical and other capability building assistance and support to local government. Okay, so it's its function isn't just to create policies, but to also assist in the implementation of those policies. Okay, which necessarily includes capacity building and the like. All right, what else? Develop a mechanism for the imposition of sanctions. So this is an interesting one because this is basically the body that would create punishable acts or unlawful acts from which you, as an investigator, if you were to pursue that line of work, you would be looking at their resolutions, their outputs, their issuances to help you determine what they have established to be unlawful acts. And of course, that's also going to be your source for the elements of offenses. Okay, what else? Develop and prescribe procedures for the issuances of. Okay, so it's talking about the rules on issuing permits and clearances, and in a way, this already hints that those are essential requisites for some activities that, in the absence of, there would be a violation, right? So this, as an investigator, would be a hint to you as to what this body does in that area. Okay, so they develop and prescribe procedures for the issuances of permits, which necessarily obviously creates or necessarily involves the setting of the limits, and those limits are essentially the basis for whether something is violated without a permit. Okay, so moving forward, what's the last one here? Formulate the necessary education, promotion, and information campaign strategies. So of course, That's an essential part of pretty much every initiative involving environmental protection. So, no different here, okay? So the next on our list is the National Ecology Center, okay? This entity is one that belongs under the Commission, and its purpose is to provide consulting, information, training, and networking services, specifically as it relates to the implementation of this law. Okay, so that is their role. Next is the DENR. As we know, the DENR is the lead agency on anything that deals with the environment. So naturally, they would also be the lead agency in controlling solid waste. And being that that's the case, they play into the commission as the chair of that commission. So that's one of the responsibilities or functions and powers provided by this law. Okay. Others include, the annual National Solid Waste Management Status Report. Okay, this is a similar activity, almost identical activity actually, to that's done on the clean air or clean water. Okay, and the report, these annual reports are naturally intended to assess the situation at that point in time. Provide some findings on what issues there might be, and so on and so forth. Basically, it's a means to collect valuable data. Okay, and that data doesn't just sit in some filing cabinet. It provides as a basis for a number of things, of which includes those materials that the DENR prepares and distributes. Information, education, and communication materials. The findings from the status reports, in a way, could serve as a basis for what would be the contents of the information, education, and communication that the DENR would be preparing and distributing. Okay, so not limited to that, there are other, essentially any of the players, perhaps in the commission, would definitely benefit from the findings of these status reports. Okay, so what other functions and powers would we find of DENR in relation to controlling solid waste? Okay, all right, so they do, in addition to that's provided by the Commission, the DENR can also provide, and probably actually do, provide technical and other capability building assistance. Okay, so this would not necessarily be one and the same as that provided under the Commission. These are things that they do under their mandate as an agency, not under the Commission, but as a government agency. They do have a mandate to provide this service. Okay. And the target audience for this service are the local government units. Right. What else? All right, this is an interesting power that the law gives the DENR. Okay, since they're the primary or the lead agency, they are also responsible for enforcing. Okay, as they are given those powers. And one of the additional powers given to them by this law is that of visitorial powers. Okay, and think of those as the ability to visit any entity that may possibly be subject to violations of provisions of this law. So the visitorial powers allows them to do, for example, spot checks. Okay, and cite people that are not in compliance. So that's a kind of a very interesting power, at least as it relates to the subject of this course. I would imagine that there will be some investigators that would be involved as members of the party that does these visits. Okay, so what else would we find relative to the powers and functions of DENR. Okay, they also do issue rules and regulations to effectively implement the provisions of this act. So rules and regulations, so that speaks to setting parameters on what is a lawful or an unlawful activity. In other words, they have the power to define offenses in violation of the mandates of this law. So those would probably be found, those rules and regulations would actually not probably, but highly likely would be found in department administrative orders, excuse me, or DAOs. Okay, so that's that. This is a very, very short list of the many powers and functions of the DENR in relation to controlling solid waste. So let's move on to the next on our list, and that's the local government units. The law reiterates what is widely known in their, as to their responsibility in governance, overall governance. Okay, so as it pertains to controlling solid waste. Okay, they are primarily responsible for the implementation and enforcement of this law. Okay, this Ecological Solid Waste Management Act. Okay, they're primarily responsible for its implementation and enforcement. Okay, but it's specific, obviously, to their respective jurisdictions. Okay, so naturally, the governor, his or her jurisdiction would be the province, and the mayors would either have a jurisdiction over a municipality or city, depending on which they are mayors of. And same goes for the barangay officials. In fact, this law even specifies who between the barangays and the mayors would play in relation to specific activities related to controlling solid waste, namely segregating and collecting. Okay, so let's take a look at it. Okay, the law says that when it involves biodegradable, compostable, and reusable waste, the primary responsibility of segregating and collecting those solid wastes are to be conducted at the barangay level. Okay, but if the solid waste, the subject solid waste are non-recyclable materials and special waste, in those cases, the responsibility falls with the mayor of the city or municipality. Okay. Next on our list of institution is actually, it appears as one bullet point, but there are really two entities that we are, or at least two levels of entities that we are referring to. Okay, they are specifically they are solid waste management boards. Okay, but there are two levels that are included in this one bullet point. You have one at the provincial level, and then the second one at the city/municipality level. Okay, but essentially they serve the same function. They only differ in their jurisdiction. Okay, and insofar as what that function is, it's really this. Okay, their primary purpose. They have other roles and other functions and responsibilities pertinent to, controlling solid waste. Okay, but the very basic sense, the very basic function and responsibility that they have, that I at least want to put focus on, is the implementation plan. Okay, the implementation plan for the safe and sanitary management of solid waste that is generated in their jurisdiction, the geographic and political jurisdiction. Okay, so there's two activities involved in that plan that they are responsible for. Naturally, the first is for them, to create it, to draft it. That's their function, initial function is to actually create this implementation plan. This goes to the commission for the commission's review and approval, and once it's ready to be implemented, they are then the board, they being the board, they are then the ones responsible for implementing it. And you might recall when we were talking about the responsibilities of the commission, among the things that they do, related things that they do, is to monitor the implementation of these types of plans. Okay, so there you have it. You have this very basic responsibility, and you have boards, multiple boards. There's one at each level, not literally one at each level, but you do, depending on, I mean, there's one for every province, right? And then you have one for every city and one for every municipality. Solid waste management boards for each of those particular jurisdictions that I spoke of. Okay, I hope that is clear. Let us now move on. I think at this point we're pretty much done with institutional mechanism. So we're going to move forward as quickly as we can so we can proceed to the next topic. And what we're going to discuss now is the comprehensive solid waste management program itself. Okay, the law provides some specifics, and we're going to pick and choose the ones that are worthwhile discussing, and that's what we're going to focus on. So again, we're done with the institutional mechanisms, so we're now going to move to the comprehensive solid waste management program. Okay, I think you will agree with me when I say that every program, in order for it to be effective, requires a good plan, right? There has to be some kind of a plan that provides for the means in making sure that it is effective at its goals. So there is no difference here. When we're talking about this solid waste management program, it has to be based on some plan, some comprehensive plan. Because as we've seen, this is kind of a really, really broad area. Okay, so there has to be a plan, and the question then is, what plan does it have? The plans that we're referring to here are the 10-year solid waste management plans. Okay, there is not necessarily just one plan. There is one for the entire nation, but there is also one for various locations. So there'll be a number of these plans. Okay, anyway, so basically, when we're talking about this comprehensive solid waste management program, it gets its directions. It's basically its instructions on how to proceed from these management plans. Okay, these are, as we've said before, these are the blueprint on what the organizations that are mandated to implement, it's what they would use as their map, if you will, on how they're gonna basically reach the objectives. Okay, so anyway, the question though is, I said these are very, very comprehensive. So that's why the images that I use here to characterize them are big books. So they're very comprehensive. They cover a lot of things, and naturally putting them together it's not something that can be done quickly, and it's not one that can be done in a vacuum. And when I say in a vacuum, where you're not interacting with other entities that could contribute to developing an effective plan. So the question is, how does the law ensure that it's not done in a vacuum and that it is truly based on something, not just anecdotal data? Okay, and so the law provides for the way it can, that can be ensured. Okay, and it starts with the annual reports that are done by the DENR. We've said this before, that the DENR does annual status reports. Okay, they do this not just for solid waste, but you've heard when we were talking about clean water and clean air, they do it there also. These are again our annual reports. They're done here also for solid waste, and the purpose is to be able to assess the situation at that point in time, identify issues, opportunities, those sorts of things. Okay, so bottom line is these status reports provide some very valuable data, very valuable and current data. Okay, and since that is the case, they are the primary basis as to how the framework is to be developed. Okay, so that leads to the next question: how does these reports, how do they end up becoming part of that framework? Okay, well, again, these reports, they eventually get submitted to the Commission, the National Solid Waste Management Commission, and that commission, as we've said, comprised of who's who in the government. Diba sabi natin there's 14 government agencies. The heads of many of these government agencies in their ex officio capacity. In other words, it's part of their job, okay, as secretaries, heads of those particular agencies. It's part of their job to participate in this commission. So we've said when we were talking about institutional mechanism, obviously DENR plays in, they're the chairman. You have the secretary of the DILG also being a party to it, and a host of others, like I said. All right, so it's a very, very nicely organized. The composition is very varied, and they really do have entities that ensures that it is comprehensive in terms of its coverage. Okay, so anyway, so with this commission being the way it is, they're in the best position to actually develop that framework. And of course, they're not gonna just base their decisions on their own personal, their area of expertise. They have to base it on something specific to this topic, and that's where the status reports of DENR comes into play. So taking that all together, collectively, they are able to put together the National Solid Waste Management Framework. Okay, and that framework provides as the baseline. Okay, because again, it assesses the situation in the country, and since it has some starting points, a base that every entity that is tasked to prepare a management plan, that they're able to use this as a starting point. Okay, so they're not having to start from zero. Okay, so that answers that first issue I raised earlier. Where do they get their data? How do they proceed? Do they just pull it out of the air? And of course, the answer is no. They base it starting with this. They start with this as a starting point. They start with this framework. Okay. So having said that, naturally, that of course means that framework is something that is made available to the people that would be creating these plans, and these people that I'm referring to are the waste management boards. Okay, the waste management boards of the province, the city, or municipality. Okay, generally the composition, we've said this earlier, there's members of the local government unit, but there are other participants also. So it's a very, very diverse group, just as diverse as the commission, but diverse specific to the jurisdiction. So they're probably the best organized, the best to be able to come up with this solid waste management plan for their given territory. Okay, so anyway, so that's that. They're able to tap the framework, and from that they're obviously able to take a stab at developing a solid waste management plan. A key point is that they're not just going to base their drafting on the framework. The framework is just a starting point, as I've said a couple of times. Okay, they're naturally having to gather their own data given the circumstance in their geographic jurisdiction. So they gather whatever they can, they take what they can from the framework as the baseline, and collectively they are able to come up with a draft, okay, a draft of a 10-year solid waste management plan. And basically that draft is what gets submitted back to the commission for the commission to review and approve. And of course, if the commission approves it, then that is the plan, the blueprint that the local boards are going to use to implement, because they're the ones that are mandated to implement. Okay, so that's kind of the flow. All right, a couple of points I want to make. If you read the law, you may notice that it almost seems to say that yung ginagawa ng DENR to create the status report is a one-time thing. It's only intended, a few months after this law was put into effect. Okay, and there's also some discussions, similar discussions about a one-time activity of the commission. Okay, so yun lang. I mean, that's the language of the law. It sort of says, to get this started, okay, the DENR has to do a status report, and it almost sounds like once they've done that and they're able to submit that to the commission, tapos na yung trabaho nila. And the answer to that, of course, is it doesn't end there, because the DENR does these status reports annually. Syempre, they're able to gather on a regular basis very valuable data, very current, valuable data. So it would only make sense that data continues to flow to the commission. So there are decisions that can be made, perhaps to update the framework, okay, so that the local boards always have current information, okay, that they can use. Okay, so again, this is even if the language of the law seems to say it's a one-time activity, surely these are ongoing interactions. There are ongoing synergies between these agencies. Okay. So anyway, the one thing I want to point out also is that the use of the framework is not the only service that these local boards would avail of from the commission. Again, we've discussed it briefly in the institutional mechanism when we were talking about the powers and functions of the commission. Basically, the other services that the local boards could avail of from the commissions involve not just policy, not just the framework, but assistance in a number of ways. There were some things that we mentioned. For example, capacity building or capability building programs. I didn't mention some funding, but there are also funding available. Okay, so bottom line is that there is an ongoing service outside of just policy making. So those services are services that the local boards can continue to avail of from the commission. Okay, but I think the one thing I want to mention, which you might recall when we were discussing institutional mechanism, DENR also. So it's not just the commission and the boards, but DENR also has some services specifically for the LGUs. Services that are above and beyond that provided by the commission. So on their own, based on their mandate, they do provide some assistance to the local LGU. So you can see, there's a dynamic relationship between these bodies that allows them to continue to work together, and basically that allows the local boards the opportunity to ensure they have all that they need to produce comprehensive plans. Okay. The other thing I also want to mention is the plans are 10-year plans, right? That, of course, does not mean that they're going to wait. Everybody waits until that 10-year period expires before they check to see how successful it was. They're not going to wait that long. The law requires that there be some mechanism for checking on a regular basis, and the more common time frame for reviews is biannual. In other words, every other year. So after 2 years, every other year. So every 2 years. Okay, so there's a review that happens every 2 years, just to make sure that the plan, as it's being implemented, is continuing to be effective. Okay, so there, as you can see, medyo talagang comprehensive talaga itong plan na to. All right, and it's not a one-time. This flow that I showed here is not a one-time occurrence, but rather it's an ongoing thing. Those entities that we are looking at there are there. They're there specifically for this purpose, to control solid waste, and they're going to be there until the law says otherwise. And currently the law mandates them to be there and gives them responsibilities beyond just this flow. It's an ongoing thing that they're having to be involved in. All right, so that should in essence give you a high-level view of how the law ensures that the plan, the implementation plan, the management plan, which is implemented, is comprehensive, that it's holistic, it covers all aspects, and that there's a mechanism to ensure that there's regular checks, so that if there are any problems, they could be discovered early enough. Okay. So you can sort of see that. So this should give you, I would say, at a high level, it should give you enough to know that indeed, when they say it's comprehensive, it's pretty comprehensive. Okay. So with that said, I think we're done with this tab, and we should now be able to proceed to the next tab, activity-specific rules. In its aim to control solid waste, this law provided special rules for specific some particular activities as well as topics. So let's take a look at specifically what these activities and topics are and see what kind of rules may have been set for some of them. Okay, so there are about 8 that the law enumerated, and under each there are again special rules that it made provisions for. So let's take a look at a few of them. Let's start with the first one, segregation of waste. The law provides under section 21 that there is a need, and this is of course referring to the segregation of solid waste. Okay, the law specified that the LGUs are mandated. Okay, it is their mandate to evaluate alternative roles for the public and private sectors when it comes to essentially collection, of solid waste from them. Okay, so the roles that it's talking about is how they might best be able to collect those solid waste from the public and private sectors. Okay, so in providing that mandate, it qualified that whatever outcome, whatever the LGU decides, it specifically states that there must be a, when it comes to segregation of waste, the actual act of segregating the waste, regardless of what the LGU decides on the role of the public and private sector, okay, regardless of that, segregation of waste must always be done primarily at the source. Okay, so what that means is that regardless of the decision that the LGU makes on the collection from the public and private sectors, okay, by the time that collection is made, segregation should have already been done, because again, the collection is being made at the source. So the source is, of course, either the residence or the office of that public or private sector. Okay, so what this is saying is, again, regardless of what decision the LGU makes, by the time pickup is made, the solid waste should have already been segregated. In other words, all the cans in one container, the bottles in one container, paper in another container, the perishables on another, etc., that kind of segregation. All right, so let's take a look at another. Okay, this one, let's take a look at composting. Okay, composting. Now this one, the rule that the law provided essentially just makes it so there is a standard that has to first be met, okay, in order that compost products may be commercially distributed. So before they are commercially distributed, these compost products must first meet the standard for organic fertilizers as set by the Department of Agriculture. So there would obviously be a need to reference the Department of Agriculture for that standard, and you would naturally do that to determine if this compost product is fit for commercial distribution. Okay, so again, the special rule provides for that. All right, so let's take a look at one more. This one, why don't we take a look at the one on incentives? Okay, it's a little different because it's not setting any specific rules on what you cannot do or what you need to have before you can do certain things. This one actually it sets the rule on what must be met before an incentive may be granted. Okay, so section 45 talking about incentives, and it says reward. Let's just read it. Rewards, monetary or otherwise, shall be provided to individuals, private organizations, and entities, including non-government organizations, that have undertaken outstanding and innovative projects, technologies, processes, and techniques or activities in reuse, recycling, and reduction. Said rewards shall be sourced from the fund herein created. So this just sets the rules on when that incentive may be granted and availed of. Okay. All right. So that should give us a general idea of these special rules on particular activities or topics, okay, that the law needed to make provisions for. Okay, so I think we are now ready to move further along. Now, looking at the punishable acts, these provisions under section 48, okay, they seem easy enough. They're very easy to read, they're very short, okay, and there's only 16 of them. So it looks like it's an easy task to be able to determine what the elements might be for each one of these provisions. It certainly seems that way, doesn't it? Okay, but let's just quickly glance at them. But I do want to. What we're seeing right now is 6 of the 16. So let's go to the second page because I want to home in on a number of them, and I want to discuss them a little bit. Okay. The provisions that I want to focus on are subparagraph 9, 10, and 11. Subparagraphs 9, 10, and 11. Okay? Let us quickly proceed and focus our attention on subparagraph 9, which is this one. Okay? If we read it, again, it looks pretty easy because it's a very short sentence. But again, if you read it, it's not something that quickly jumps out at you. The elements that don't quickly jump out at you. And there's some red flags here. Okay, it's telling us that by itself, it doesn't give us the total definition of what constitutes the offense. In fact, it's even referring to other sources for that information. Okay. Moreover, okay, to help us analyze, let's just quickly break it out real quick or dissect it. Okay. It's a short sentence, but if you read it, establishment or operation of open dumps as enjoined in this act, or closure of said dumps in violation of Section 37. So there's actually two parts to this very short sentence, right? The first part is establishment or operation of open dumps as enjoined in this act. And the second part is closure of said dumps in violation of Section 37. Okay? So let's go back to the first one. It says establishment or operation. That's the particular acts, right? The act of setting something up, establishing, okay? The act of operating, okay? The act of operating something. And the something here that you would be establishing or operating would be open dumps, okay? So that in itself already tells us, it's pretty conclusive. There's nothing more. Establishment or operation of open dumps, it's easily understood, right? But what complicates it, what makes it so it's not complete, it's not seeming complete, is that it's referring to a different source where you would find that source actually says it's prohibited, okay? So being that that's the case, there's obviously a need to look for that source. Here it just says enjoined in this act or prohibited in this act. So it's referring to the entire law. That of course means we have to look at the entire law, all right? The second part is a little easier because it's not referring to the entire law. It's referring to specifically to a section, which is good. Okay, and for that second part, instead of establishing and operating, the act is closing. Okay, it's the closure of said dumps. Okay, so that's pretty clear. But again, it makes reference to a section in the law where we would find specifically the words that says that is not allowed. It's a violation. Okay, so let's first look at the first part and see if we could make sense of it. So because it's referring to the entire law, what I had to do basically is do a search, keyword search, using the keywords open dumps. Okay, so fortunate for us where everything is computerized, so we can just quickly throw in those keywords and the system will deliver for us what it finds in the law that we are looking at. And in doing that, I did find that there were 13 hits, and so I looked at every single one of those hits, and I did find the exact provision, the exact section that does say explicitly that this is not allowed. Okay, and coincidentally, it's Section 37. Okay, so this now makes it easier for us because now we could refer to the same section for these two parts. Okay, so what I did then here is I copied that provision and here it is. So let's now do our analysis. Okay, let's quickly read it. Prohibition against the use of open dumps for solid waste. That's the title. Okay, and the provision starts with no open dumps shall be established and operated, nor any practice or disposal of solid waste by any person, including LGUs, which constitutes the use of open dumps for solid waste, be allowed after the effectivity of this act. Okay, so there in what we just read, we're seeing that the specific acts are, again, the act of establishing and operating open dumps. It explicitly said that you cannot do that. You cannot you cannot establish or operate. In addition to that, it also says that you cannot dispose of solid waste, okay? Whether you're a member of the LGU, or just a regular average person, the act of dumping, the act of disposing of solid waste, into an open dump site constitutes the use of open dump site, okay? Which is not allowed, all right? So there you have it. That first part talks of 3 specific acts that are not allowed, right? But we didn't find anything in what we just read that talks about closing a dump site, as to whether it's illegal or not, okay? So, and if you read the entire paragraph, the entire section, you're still not going to find anything that talks of closure as an unlawful or prohibited act. So how do you proceed then in finding an answer for that? Well, in cases like these, you'd have to just read the provision itself and try to understand it without regard to a particular keyword that you might be looking for, okay? Because it may already be telling you something that addresses what it is that you're looking for. So, that's precisely the case here, because, after what I just read, where it says, establishing and operating nor using open dump sites are allowed, right? It goes on to clarify that the effectivity of that prohibition is based on the effectivity of this law. So effective, when this law was put into effect, it became unlawful to establish, operate, and use a dump site, an open dump rather. However, there is a proviso, right? It says, provided that within 3 years after the effectivity, LGU shall convert open dump sites into controlled dumps. So in other words, there is an exception, okay? There is an exception where those open dump sites could still be used. And that exception is only good for 3 years from the effectivity of this law, okay? So for 3 years after this law was put into effect, you could still dump, controlled dump anyway. You could still use an open dump site, but in a controlled way, regulated by the local government unit. Okay, and it goes on to say that for another 2 years, a total of 5 years. It says on here that a total of 5 years reckoned from the start, or reckoned from the effectivity of this law. Okay, on the fifth year, the day after the 5th year. Okay, those controlled open dumps were completely closed. Okay, so what that means is from that point forward, the day after the 5th year, open dump sites are completely closed. They're completely prohibited. You can no longer, you couldn't anyway. You couldn't you couldn't establish or operate, but for some time you were allowed to use them. But starting on the day after the 5th year, no more. You couldn't use it anymore. Okay, so with that message, it essentially telling us that whether you are establishing, operating, dumping into dump sites, or even in this case closing dump sites, okay, regardless of what it is that you're doing with dump sites, dump sites are no longer legal. So what that essentially means is it's moot, right? So we don't have to be looking for this, closure of said dump sites as a provision that is prohibited. Bottom line is no more dump sites starting in 2005, the day after 2005. Okay, so that answers that question. All right, so let's move on to the other provisions, because the other provisions also are similar to this in that it requires a little bit more analyzing. The way they're put together, they seem simple enough, but they do require a little bit more of an analysis. Let's pull them up at the same time. The manufacture, distribution, or use of non-environmentally acceptable packaging materials. And then the second one is importation of consumer products packaged in non-environmentally acceptable materials. Okay, so they're short and sweet, and they seem rather easy to understand. but you could easily miss, essentially the one thing that distinguishes whether those acts are unlawful or not. Okay, let's say you're surveilling someone, and there's someone you're suspecting is a manufacturer, a distributor of, let's say, candy, and he or she obviously uses packaging materials for the candy that he manufactures and distributes. The question then, in order for you to conclude that he is committing a crime in violation of this provision, is his packaging materials, are they environmentally acceptable? How do you know if it's environmentally acceptable, right? So you have to look into that. And like what we did in subparagraph 9, where we took open dumps as a keyword, I also did the same thing here. You actually have to do something like this. Using non-environmentally acceptable as the keyword, I went into the law to see if there's anything there that qualifies what non-environmentally acceptable is. What are the parameters that constitutes something to be non-environmentally acceptable? So the search also produced a number of hits, namely I think there were 9 that it found, and there were 2 particular provisions that made the most sense. One specifically, and that specific one is the one that we're going to focus on right now, and that one is referring to the powers and functions of the Commission. Remember the Commission? Okay, Section 5. So it talks about exactly what powers and functions the Commission has, and one of those powers and functions is to formulate and update a list of non-environmentally acceptable materials. Okay, so they are the ones that come up with a criteria, and they're also the ones that maintain the list of the items that are non-environmentally acceptable. Therefore, you could just conclude that you just need to have access to that list, right? To see if the guy that you're surveilling, if the material that he's using to wrap his candies with, if it's in that list, okay? And if it is, then there you have it, right? He's violating this provision of law, right? Sure enough, that's really, as easy as it gets, right? But the one thing that you have to just keep in mind here is that, and I'm going to refer, I didn't have it on here on the screen, but I'll just refer to it. The second provision I found under non-environmentally acceptable is the one that talks about due process, in relation to this list that the Commission maintains. What that means is that if there is a material that looks to be non-environmentally acceptable based on the criteria that's set by the Commission, they don't just automatically add it. Okay? They give whoever is affected due process to try and duke it out, right? So they do provide, as part of standard due process, notice and hearing. So there's notice that a hearing is going to be held, so that if anybody has any arguments, opposing, the act of adding something to this list, then they have the opportunity to do that. All right. So anyway, having said that, what you would need to do then is you don't just go and look for this list, but you look for the list that has undergone that due process of notice and hearing, and for a fact that this is the published one. Okay, it's the authoritative one. That way, when you cross-reference it against what you're investigating, and you've concluded that it's the materials that are being used are indeed on that list of non-environmentally acceptable, you can say with certainty that this person is in violation, because that he's manufacturing, distributing non-environmentally acceptable packaging materials, right? But remember, you have to use that authoritative source. Okay, otherwise, it may not be conclusive that the violation is indeed a violation. Okay, So there you have it. I'm going to leave the rest of the provisions for you to play with, exercise with. I think there's a few more that are a little like this. So I would suggest, playing around with taking a look at the entire list of 16 and seeing if you could make sense of them the same way that we did on this exercise. All right, so anyway, I think we're pretty much done with this law. And just the same, I think we're pretty much done with this lesson. And also, being that this is the last of the 2 lessons under Brown laws, we are essentially done with Brown laws. Okay, so I think at this point I'm going to close off, say goodbye, and I look forward to talking with you again on the next module, module number 4. Until then.